This. Put this over here. Get my setup going here. Let's share. Window, and we're going to share that right there. All right. Mr. Bill, give me a thumbs up. You see that? Good deal. All right. I know that many of you saw, we have our agent, Jennifer Solak, also a probate attorney, did a training on probate last year. HomeSmart saw that and said, hey, we could do something like that, kind of a broad overview of kind of the different probate process for across the nation. Obviously, each state is a little bit different. I just dealt with a probate in Colorado, different than in Texas. And then, of course, in Washington, we had one. In Arizona, we had one. So definitely very fresh in my memory. So hopefully those that are dealing with this, we have a lot of questions from agents that they have a listing, from a family where they lost someone in the family and they have to sell the house. And many of the questions have to do with, well, there's multiple heirs. What do we do? What's the simplest way of doing this? How long will it take to get on the market? What do we have to do? So some of those questions will be answered today, but just to get an idea that there are, life happens, and so we have to be prepared ourselves to make sure we know what we're doing with our property in case we lose our lives. But we also have to be prepared to help our clients who are, they're faced with these things oftentimes unawares, and then they don't know what to do. So we can help them through the process. Okay. Obviously, properties and probate. We're going to be covering a brief overview of what it is and how we as real estate professionals should handle navigating these properties. Generally speaking, they're not quick, like any other thing that has to do with the courts, whether it be a bankruptcy appointment or even a foreclosure or whatever. Just be aware they're not going to be one of those things, a simple 30-day close in most cases. Not always, but just be aware of that. Next up, obviously today we're trying to do an overview of the probate, the different options, the different routes some sellers can take when selling a property. And so we're going to understand the process a little bit better about buying and selling properties in probate. We're going to figure out what probate is, sort of key terms, what is probate like if there's a will, and what's probate like if there's not a will. How to avoid probate in general. There's a couple different paths that a seller or a family can take. How to help buyers buy probate properties. Miguel's coming in. How to help sell probate properties. Once again, that's probably the most common because the buyer side agents dealing with properties that are going through probate, the biggest thing for them is just to navigate the timeline and getting approval to sell the property. As long as the seller has the proper approval to sell the property, the buyer usually can handle that as like a normal transaction. All right. Anybody have dealt with probate recently or this process? Yeah. I know a lot of our agents have, whether personally or professionally. I know one is dealing with that now currently as well. So, okay. And then we'll cover a couple potential obstacles as well. People continue to join us. Good morning, good morning, good morning. All right. So diving in, next up is what is probate? And of course, when you hear probate, what do you think it means, right? It's very legal sounding term, right? Well, here it is. Probate, it describes the legal process for reviewing the will and assets of a deceased person, often called a decedent, and determining how those assets will be distributed. So basically, when you pass away, how much do you owe? How much do you have? What's worth? And a process of reviewing it and who gets what. It says it alerts creditors that an estate has been opened so they can make claims as necessary. In most estates, when you pass away, if there's debt owing, the debt has to be paid. So they give public notice out so that debtors can make a claim against the assets of an estate. Okay, come on in. And then the process that's used to name somebody to replace another's signature when they're no longer able to provide signature. So it's a probate process. It says the person's no longer alive. They can no longer sign for themselves. And one of the kind of interesting things I found out during my process, during my mom's estate, was the fact that if you have a living power of attorney or a durable power of attorney, while they're alive, you can make healthcare decisions on their behalf. You can sign for property on their behalf and do those kind of things. Once they pass away, your power of attorney is non-existent. It doesn't carry over. So you have to have either a place appointing you or the judge or attorneys going through the court process to make sure that you're the representative for your state. That was an eye opener for me. So just the probate process assigns somebody to be in charge of taking care of the assets and paying off the bills and that kind of stuff. All right, that's probate. A couple of key terms in any state we're in, they may be named a little bit differently. The first is the executor, appointed by the deceased in their will, responsible for executing the will's instructions. So if the person who passed away, the decedent, had a will that's signed, by the way, and my mom had a will, but she didn't sign it, so it didn't matter. She didn't have a will. So if there's a will in place and it appoints an executor, that person's responsible for executing the process of administration of the state, the dissolution of it. Administrators are appointed by the court when no executor is named or available. They're responsible for managing the state. Now, administrators can go by different names. In Colorado, it was a personal representative. In Washington and Arizona, it was called an administrator. So it depends on what it is. But they're basically people appointed by the court in lieu of basically an executor to manage the estate's process going through probate. And then the beneficiaries are individuals and entities receiving assets from the state, the estate, if you will. So obviously that could be family members, it could be debtors or that you owe debt to or the estate does. So here we go. The deceased or decedent, the person who's died, if this person has made a will, they are a testator. And obviously that's where you get the word, if they didn't have a will, it's called intestate, meaning they didn't give a testament, right? So a will is a testament of their desires when they pass away on how things are supposed to go. So intestament, basically intestate, means there's no will. So heir, the people legally entitled to the deceased property if there is no will. This is usually the surviving spouse or children of the decedent, or if there's no surviving spouse or children, then it's likely the decedent's parents or siblings. Now, there's some exceptions to this generally, and we'll get to that shortly, but that's usually the closest to the person who passed away is usually the heir and entitled to whatever's left over. So with our job, obviously, is to make sure we know who the heirs are, who's the closest, who has a right to sell it, who's been assigned as a personal representative, who's the executor. We'll get to that in a second. The questions we need to ask a seller when they're going through this process and when they can sell a property. So typically, how long does probate take? So the amount of time a probate takes depends on a variety of factors. How complex the estate is, what state the estate lives in or is in, how well the personal representative handles the duties assigned to them, how busy the courts are, how long it takes to get before a judge to make these things and choices, and whether anyone contests the will. So if there's a will in place and there's a family member, an heir that says, no, I don't like it, I'm contesting it, you can do that. In Arizona, we dealt with one where a will was contested. It's interesting how that slows things down because they have to go through the whole court process to see if they have standing, basically. Okay. All right. So if there's a will, can the property avoid probate? And of course, this is a very clear question. A lot of people say, oh yeah, I've got a will, we don't need probate. No, all properties go through probate. It happens to be the probate process required a will, but it makes the process easier because there's the decedent's already laid out in writing who they want to be the executor, where things want to go. So it smooths the process and makes it go faster. So what is the probate process like if there is a will? And again, the qualifier there, it depends on who's involved. Once again, it can be the people involved can make it much more difficult, or they can make it a lot simpler based on here's mother's, father's, grandfather's wishes. This is what we want to do, and we're all on board. All right, so there are a couple different paths. Obviously, probate. So probate, there's one with a will, makes it, but there's full probate and there's other options. So one potential path that may occur is full probate, which is the one I went through with my mom's estate. So they names an executor and receives letter of testamentary. Basically, my brother and I, the two heirs, had to agree that we are the only heirs to the property. And then we have to sign off on that. And then we had to appeal to the court to become the personal representative for my mom's estate, even though we're the only two heirs in the property. Still, same thing anywhere else. You've got to have an appeal to a court if there's no will. Even with the will, you have to say, here's the will, what it says for the executor. They name an executor and they need letters of testamentary, say, hey, this is stating fact, we are the heirs. These are all the heirs involved. And then allows the executor to transfer title to real estate and allows the executor to act on behalf of the estate. So basically liquidate furniture, belongings, bank accounts, that kind of stuff, and pay off any existing debtors, and then disperse whatever is left over to the remaining heirs. That's basically a full probate process. There's a second pathway, which is I don't even know how to pronounce it, muniment of title. It's a lesser way, and it's only dealing with real estate only. So if they want to get someone appointed to transfer just the property, and in my mom's case, that's all she owns of his property, but can be used to transfer title to real estate only. It allows basically you to create your own plan and avoid potential state plans. So you have a plan about selling the property. So some of your sellers may be going, all right, we have to do a full probate. We have to get assigned as an executor. We have to get letters of testamentary. We have to get all the people agree, go through the process of basically managing all of the estate. And then there's like, all we have is a house. Here's a simpler way, just dealing with title. And so then it goes into what if there isn't a will? If there isn't a will, there's a few different ways things may proceed. You can either go by the full probate route, which we just saw, or non-probate routes, which is, we see a lot of this in Texas, believe it or not, the non-probate routes. So if there isn't a will, the probate route is a two-part process. The first part of the probate route is judicial. The determination of heirship. During this process, your family has to submit to the court what the facts are of your family and essentially prove that you are the actual family. So here, we went before a judge showing that my brother and I were the only heirs to the property. So there's no cousins, second cousins, no husbands involved. There's no that would be in line to receive any of the assets. Okay. And then we had to the application for administration. So applying to sign on behalf of the deceased. So I had to apply to become a personal representative, and my brother had to agree to it. So the next part of probate route is for application of administration. When there isn't a will, there's no executor. So after completing the judicial termination of heirship, you need to complete an application to become an administrator. This means that someone is applying to sign on behalf of the deceased. The goal of this process is to achieve independent administrator because that means they could sell a house without the supervision of a court. You don't have to go back to the court to approve a sale. You can liquidate stuff. And so, and obviously we've seen this happen when you have multiple heirs, and it can be difficult because then you get the infighting amongst each other about who's going to do what, or if the personal representative is doing things the correct way. So we have to navigate that process as well. Small estate, this is one that is pretty common in Texas. We see this a lot when the entire estate, meaning is less than 75,000, and does not include the primary residence. So they have a house and less than 75,000 in total like assets. You can do a small estate affidavit signed on before and basically give permission to liquidate the estate without going through a full probate process if there's no will. We've seen this quite often. This is one of the first ways they say to go with a small estate affidavit. It's an application by the family to the county. They fill it out, and the county goes before a county judge to approve the small estate affidavit. That deals with bank accounts, deals with the property, deals with allows you to basically liquidate it in the process. So that's one of the options that you should talk to your sellers about wherever they're at. There's a will, they go for the full probate process. There's executor signed. They have letters of testamentary. They're good. If there's no will, the first option is full probate, where they have to go to a judge to pick one of the family members to be the personal representative, the executor, same process. Option 2 is they can go through a small estate affidavit, basically make an application to the county, going before a judge to say, hey, the estate's not that much. Allow us to liquidate it on behalf of the estate. Okay. And then this is a probate process, but it's a quicker method of doing so. And then the third option is the affidavit of heirship. This is one that I've seen unique to me. I mean, there's several states that do this, but specifically Texas. This is one where we've seen a lot of properties transferred through the affidavit of heirship. So it's a non-probate process that's used very often. The benefits of doing an affidavit of heirship is it's simple and cost effective. It's quick. We've seen this with multiple heirs where they sign up and say, yep, here's our affidavit, here's our family history, here's the family members, here's the number of people that are heirs, and they basically record it, and then they're allowed to sell the property through this affidavit of heirship. They're testifying that, yep, we're the heirs, we're all the heirs, and this is what we want to do. So it's a non-probate way of transferring property. So that's the benefit, is it's quick and fairly easy. We're talking about a few weeks to a couple months. The drawbacks, though, see, in a probate process, you through the formal and with a will or without a will, the estate is posted and advertised, so all creditors, anything that's owed against the property, owed against the estate, can make a claim against the assets. And then there's a process that goes into it. Has to be advertised for several weeks, multiple times. And then if the creditors come forward, those creditors have to be paid before any of the assets can go to the heirs. Simple process. And then once the estate is closed or the probate is closed, there's a year waiting period generally on these things where those creditors can come after the estate even when the money's been dispersed to the heirs. Now, that's a full probate. In this case, though, the affidavit of heirship, it's faster and it's non-probate. So it means that estate creditors may sue the heirs directly, including the omitted heir. So if 8 of the brothers and sisters all said, yep, we're the heirs, and there's a 9th brother out there, they're not protected. The creditors that weren't paid can still go after each of the heirs individually because it doesn't provide the probate protection. So if the seller is selling a property and they can't go through probate for whatever reason or don't want to spend the money, it's $3,000 to $5,000 typically for the probate process, and it takes time. It takes anywhere from 2 to 6 months generally, plus that waiting period, if you will. So if you go this route, you could probably do it in 30 to 45 days to get on the market. But the sellers need to be aware that the heirs are still liable and can be sued personally by any of the debtors. So they want to make sure that any debt against the estate is known and is paid before the heirs get any of the proceeds. Okay. And of course, if the estate includes debt or a complex family situation, a formal probate may be the best solution. Again, through formal probate, once that window closes after those that made claims are paid, anybody else, and the window closes after a year and no other debtors make claims, the debtors that still are owed they can't have a claim anymore. It's closed. The window's closed for them to get assets. Whereas in an affidavit of heirship, that window never closes. So be aware of that when we're selling. Because we've seen a lot of things come across my desk where the seller sold it through the affidavit of heirship, and I'm not sure if they understood, that they're still open to basically being sued. All right. So is having a will enough to transfer my property? And of course, having a will is not enough to transfer your property. A will only goes into effect when someone dies. It says people need to make a plan who can manage your assets, including your home while you're living. This is something that I'm working on, my wife as well. We should all look at this. as we look at what we have as far as assets and debts and so forth. So there are three ways a property can avoid probate. Okay. There's the revocable living trust. There's beneficiary designations. There's a transfer on death deed, which we'll talk about in a second, and the irrevocable trust. So there's different ways you can talk with your accountant or your attorney and look at putting things in place to avoid having your heirs go through a probate process. Whether they have a will or not, there's still a probate process involved. So the first thing is a revocable living trust. This basically means the assets you have are held in a revocable living trust. Typically, it bypasses probate. So this is one of those things that you can put in place. You can revoke it. That's with the name any point in time. But typically, if it's in there when you pass away, it passes in with the trust into the designees, whoever you have it in line, beneficiaries. The beneficiary designations, so anything that's beneficiary designated doesn't go through probate. So bank accounts, IRAs, annuities, that's spelled wrong, by the way. Anyway, these type of things, they typically, you sign up, you have a beneficiary, your son, your daughter, your sister, your brother, whatever it may be. Those don't go through the normal probate process, which is nice. They can go through the small claims, the small estate, if you will. But other than that, typically they don't. Okay, next one is transfer on death deed. This is one that I've seen recently. It says allows you to pass your real estate directly to another person when you die. It's easier and less expensive to set up and maintain a trust, and you can revoke it during your lifetime. My dad did this. My dad was remarried after many years of being divorced from my mom. And then a couple years before he passed away, he did a transfer on death deed so that when he did pass away, that his wife would get the property. Because in Arizona, where this would happen, on normal death, on a normal deed to the property, half would go to the wife and half would go to the heirs, his children, basically. And since we're grown adults, he's like, I want to have it all go to the wife, but she still has a young child. So, and there you go, transfer on death deed. It's an option for those that are thinking about in the future, not having the family to deal with probate. Okay. The irrevocable trust, obviously, it is what it is. It's much weightier because you can't change it once you put it in there. But it's a trust anyway. All right. Questions we as agents need to ask a potential seller. We're going to a listing appointment. They're going through, they've lost a family and belong to mom, aunt, brother, whatever it may be. Have you seen a probate attorney? You know, where are you at in the process? Is there a will involved? Is there a will? Great. Can I see a copy of it? If it is, we got to make sure it's signed, make sure it's an actual official will. And if they've seen an attorney and they're working through the probate process, you know there's a timeline involved, or the executor, and then you want to find out who the executor is if they've gone through this process. If they're just starting, you say, all right, you should probably talk to an attorney, probate attorney, to figure out your next step. And I can talk to you about how to market, how to whatever, but we probably have a little bit of time before we can actually put this on the market and get it sold for you. All right, next up is how to buy real estate, right? Sometimes the executive estate will need to sell the property as part of the probate process. Typically, that's what happens. It can be an appealing as an investment strategy because you look for probate. Sometimes they want to liquidate them as quick as possible. But some of the downside there is you may need a larger earnest money deposit and approval from the probate court to purchase, depending on where it's at, if personal representative or through probate, or if there's a lot of debt owed against the property, there may need to be a certain amount that the executor has to get for the property. In most cases, though, when there's plenty of equity, not a lot of debt, it's pretty quick and easy, but you might get a pretty good deal on a probate property. All right. And then how to sell properties. Obviously, you may need to hire an independent appraiser to determine the property's market value, especially if you have multiple heirs. You may want, you may work with a realtor, get a CMA and whatever. But if you're the personal representative, in my case, you may want to get a professional third-party opinion. So the whole family sees property's worth X. So this is what we're going to sell it for. You want to sell the property for no less than a certain percentage of the appraised value. Otherwise, the probate court may not approve it. So if you, let's say it's worth 500 and you sell it for 400, that may be, they're like, why are you selling so cheap? there's debtors to pay and so forth. So make sure that it's close to what it's worth. And then publish the notice of sale in a local newspaper for a certain number of consecutive weeks. So this is one of those things where when you open probate, you have to announce it in the local newspaper for several weeks in a row, that probate's open, that debtors know that there's an estate open, that probate's open, that they can make a claim against any assets. Same thing for the sale. It's got to be advertised that this property is being sold through probate, again, so debtors can know. I mean, people, not debtors, the people that are owed the debt. The creditors, there we go. The creditors can make a claim against the property. All right, a couple things when working with probate properties and probate, there are some potential obstacles that we may encounter. The first one is pretty obvious, is title issues, right? If we don't know all the heirs, we have to verify the title thoroughly. Probate properties may have complex ownership histories, and unresolved title issues can complicate the sale. I've seen a couple of these fall apart because of title issues, because there was one of the heirs wasn't notified, still had to be signed off. Sometimes there was a sale in between family members that wasn't recorded. So you got to make sure that we stay on top of title, make sure that's reviewed to avoid any issues in a sale. Obviously, legal requirements, stay informed about probate laws, ensure that we're in compliance with them. Our job is working with the probate attorney and the sellers to make sure that we're in the right, for following the process. Our job is to market it. And when we market it, if it's subject to court approval, we got to make sure that the buyer's agent knows that and it's part of the contract. So we don't want to make promises that we can't keep, right? And then multiple heirs. Probate properties often involve multiple heirs, and conflicts among them can arise. Be prepared to navigate disputes and work diplomatically to facilitate an agreement. This is big. We had one recently, had like 18 heirs, and they were trying to sell the property through the affidavit of heirship, and the heirs were causing problems and allowed them not to sell the property. So they had to go through the full probate with a judge and everything, because the heirs could not come to an agreement. And that killed the sale. The buyer went on and went out somewhere else. So, and then property conditions and repairs. Probate properties may be in varying stages of disrepair. Assess the property thoroughly and factor in any necessary repairs or renovations when determining the listing price. Big deal here, because oftentimes the heirs don't want to spend money to fix the property up. Typically, they want to sell it as is. In some cases, in a personal case, my mom's house, we had to actually put about $5,000 of our own money to make sure it was sellable in order to sell it. So sometimes that's the case. You get reimbursed for that if that's the case. But just be aware that oftentimes these properties may be in disrepair. They may not be in disrepair, but the point is typically the family members have to be involved, and they may not want to invest money into the asset. All right, and a couple more potential obstacles. There's delay. Understand the probate process can be lengthy, and court approvals may take time. So be patient and manage expectations regarding closing timelines. We've seen a few of these come through. Trying to close in 30 days is impossible. Depending on your county, how busy the judges are, how proactive the probate attorney is, how proactive the executor is. We've had some cases where the executor or personal representative had a full-time job, so they were doing this on the side, and it takes longer. So those are all involved, and it takes time. And then, of course, incomplete information. You have to make sure you know everything about the property and all the records. Make sure that the family members or whoever's the executor really is on top of things. Make sure that the paperwork is tight. Obviously, they're going through a lot of emotions. They're going through, loss of a family member. So being compassionate, respectful, but also firm and holding their hand to get through it. And obviously working with the attorney. If you don't work well with the attorney, you could be at odds with the family, the heirs, the property, and you can cause problems. So make sure you're working closely with their probate attorney. All right, more potential obstacles. Obviously, perception. Be aware that some buyers may have reservations about purchasing a property in probate. So develop a marketing strategy that addresses potential concerns and highlights the property's value. Like, you may get a good deal, a long time, held, well taken care of, whatever it may be. You want to overcome that sort of perspective that, oh, okay, this is an estate sale, this is a probate sale. Understanding the liabilities. So you have to investigate any outstanding debts or liabilities. This is the bigger one. Unresolved issues can affect the sale and potentially impact the buyer. So you want to make sure that the probate process is followed, whatever the probate or non-probate process, that the advertisement's been done, that any existing debts or liabilities tied to the estate, you don't want to come back and have a lien on the property that will affect the sale. So that's something that you have to make sure that the sellers are on top of that, and we as agents are making sure we're asking the right questions. Then unpaid bills and taxes. Obviously, you want to make sure that they're not in arrears in their property taxes. Make sure that they're not arrear in their mortgage. But the worst thing would happen is it's foreclosed upon during the process of probate. And then educating clients, obviously ensure that the heirs and potential buyers are well informed about the unique aspects of dealing with probate properties. So clear communication. This is not a simple process. It is a complicated one. That's why we're going over sort of the generic thing, but you should get together with a probate attorney and know more. All right. Now, you can go to each state has their own specific laws on probate. Obviously, Texas has their own. So make sure we deep dive into Texas laws. Like I said, a lot of affidavit of heirships are here, a lot of small estate filings as well, and obviously the probate process. All right, I'm going to stop this right here. Now, this is an overview, obviously, of the probate process, but there are the things we get a lot of questions, like I said, and specifically about the affidavit of heirships, making sure that we as agents aren't doing it for the sellers. Well, we can tell them to connect with a probate attorney. We've got a couple of them in our vendor list that we other agents have referred. One of them is our own HomeSmart agent, because they need to know where they're at. Are they going to go through a full probate? Was there a will, not a will? Are they going to do the non-probate? Well, and what are the risks in that? So you need to be working with a good attorney. And for us, we can give them sort of like, okay, I can list the property when I know that the person who's signing the agreement is the person designated by the court, whether by the will or whether through a court appointment as a personal representative or the executor, and then make sure they sign all the documents. Sometimes on the affidavit of heirship, you'll have people that file that. That's not all the heirs, and you need all of the heirs to sign the agreement. So those are the questions you need to ask each seller. Who has the right to sell this property? Do you have paperwork that shows you have the right appointed by the judge or through the affidavits so that we actually have a valid listing agreement? And then we can share that when we sell the property, receive an offer on the property, who we're dealing with, who has decision-making authority, that when we go to title, it doesn't get blown up because of debt of creditors or because there's heirs that aren't involved or won't participate. So, but there's an opportunity out there because obviously, there's a lot of probate properties, a lot of people dealing with losses in the family. So if we have an understanding and can hold their hand and kind of walk through the heirs through the process, it could be a niche for a lot of us to gain more business. So I hope that was helpful. Bill, you got any questions? Nope. Anybody else got any questions? Other than that, stay dry, everybody. Happy Friday and have a great weekend. Yeah, Laura, go ahead. Laura? Oh.
I didn't mean to raise my hand. Sorry.
No, you're fine. Yeah. I also, this is recorded. I'll send out the recording. I got the slide deck. I'll send out with it and the participant guide so you can go over this in more detail at a slower pace. So should help you. All right. See you guys later.
Thank you.
You're welcome.